I remember back in the day when the big argument was, once we got more representation of black people in the Justice Department, or judges and lawyers and DAs, that all of a sudden we would have this perfectly clean system where no one would be treated unfairly and there would be no dirty business happening behind closed doors. Check this out.
And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment.
So can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Now, this seems really unusual that a judge would be meeting in chambers with a state's witness and the prosecutor without a member of the defense team there. But Judge Glanville was furious that Steele found out about the meeting in chambers.
So in a nutshell, the judge held a closed-door meeting with the prosecution and neglected to tell the defense attorneys that they were having this meeting. And according to most of the lawyers who are reacting to this, he was supposed to call the defense attorneys in as well. It's hard for me to believe that a judge who's been practicing law for 30 years would make that type of mistake. And after making that mistake, instead of cleaning it up, this is what he did.
Why, sir? I'm going to hold you in contempt if you don't tell me who that. Tell me who this information was coming from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering.
Attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what. I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Glanville actually ordered that Steele be thrown out of court for the day over Steele's objection and the objection of his co-counsel.
As a result of him being threatened with contempt, this guy called an organization, and the president of this organization was the notorious Ashley Merchant. If you haven't been paying attention to the Fani Willis trial, this is the same lawyer who was involved in that.
So is it criminal contempt that you held him in?
Yes, ma'am.
Okay, and you said you had a hearing earlier today.
And with criminal contempt, I told him what the contempt was, and that was he refused to tell, order of the court. If counsel, as you know, if the court orders you to do something and you don't, that's criminal contempt. So I've asked him several times, please just tell me who it is that told you. I didn't ask or inquire about anything that was said. I just want to know who it was. Okay. Because he's got too much detail of this particular alleged conversation for the court to be concerned about it. So,
and Judge, since it is a criminal contempt, he is entitled to due process. He's entitled to a hearing, entitled to an actual show cause, entitled to the allegations actually written, entitled to a witness list. We're entitled to present our own witness list and notice of that.
Criminal contempt is different. It is on the spot. So he's gotten the due process he's going to get. That's on the spot. I told him. Plus, he's had all day to tell me who it is that is it. So a little different, Ms. Merchant. I'm going to disagree with you, but
okay. Judge, just for the record, it's that's direct. So what you're holding him in is in direct criminal contempt.
Yes.
The issue with the direct criminal contempt is whether or not to actually hold a hearing now, whether or not it needs to be held immediately. And the problem is, if you hold him in direct criminal contempt, as you're saying that you did, you are a witness to that proceeding. And so it has to be referred to another judge. Doesn't require recusal.
But then the big news came this afternoon when the Georgia Supreme Court actually stepped in and gave Brian Steele bond pending his appeal of this contempt order. So he is not going to have to go report to jail Friday at 7 p.m. I think that was expected from most everyone.
At least now it looks like the Supreme Court of Georgia has decided that something about this wasn't done right, They responded very fast, and they granted him bond, which the judge didn't do himself. Let me go ahead and clarify. I'm not a lawyer, but I am somebody who in my younger years was in and out of the court system. I'm somebody who sat across from judges and DAs, who had a conversation with a lawyer that I may have hired, and they explained the law to me, and I had to watch people step all over the law. I don't care if the person that is in that robe or the person that's in the DA's office is black, white, yellow, green, or purple. All I care is that that person is going to move according to the letter of the law. And what we found now is that no matter what color the person is, we're all human. And the system that we have in place right now, it seems to be broken. What you think about that? Let me know in the comments. Like, share, comment, and subscribe. I'll see you in the next video.